So 90%, fill in the blank. List 4 types of pleadings. That's one thing I want you to know on this page. I also want you to know basically what we mean when we use the word pleadings, which I'll explain in a minute. What are their purposes, which I have down here below. And I want you to know which side of the lawsuit files them. Plaintiff, defendant. Okay, plaintiff is the one that files the lawsuit. Defendant is the one being sued. We went over that last week. All right, so complaint is the first type of pleading. The plaintiff will file the pleading, called a complaint. That's what starts the lawsuit. Now sometimes it goes by a different name, like petition, but you guys don't need to worry about that. So these pleadings, let's just talk about the word in general, down below here. The purposes of pleadings. There are 2 of them. So first of all, what are pleadings? These are papers that lawyers file in a lawsuit to outline their basic position to the judge. To tell the judge a little bit about the case in an outline type of a format, and then to tell the judge what they want as an outcome of the case. So the lawyers will file these, or if you're representing yourself in court, you would file. There are 2 purposes of pleadings. First of all, to put on paper factual statements, allegations of fact. What you are contending happened, factually speaking. What are the facts of the case? And those are going to be in the numbered paragraphs, and I'll show you those in a minute. Okay? The second part of a pleading is where you're telling the judge, or asking, I should say, not telling. You don't tell a judge anything, right? You ask. You're requesting what we call a remedy. A remedy is what you want as the outcome of the lawsuit. Is it money? Is it a court order that prohibits somebody from having contact with you, like a restraining order? Or is it a court order prohibiting somebody from using your copyright or your patent or your trademark? Is it lost money for wages? What do you want as an outcome? So to summarize it in plain English, what happened and what do you want? Right? Those are the 2 purposes of a pleading. So, the first pleading is the complaint. The plaintiff files the complaint. That's where we get the word plaintiff. The complainant is filing the complaint. Now let me just show you kind of general what it looks like. This is highly abbreviated, but it gives you the idea. So page 35. This is not an exactly correct format, but it's close enough. So, this is a complaint. The plaintiff would file this. So first of all, pleadings have to follow proper procedure, civil procedure, in the way that you form the documents and file them with the court. So first of all, they have to be on pleading paper. That's this numbered paper over here. Probably seen that before. There's actually in Microsoft Word a macro for that, as what they call it, a watermark. Then you have to have the case caption, the name of the plaintiff, the name of the defendant, the court name. This should actually be over here. And then the name of the document, which actually should be up here. And then jury trial and the court case number that'll be assigned. So that's the caption we call it, all right? So here we have Elizabeth Smiles plaintiff, that's who filed the lawsuit, versus Coastal Insurance Company, Incorporated, the defendant. All right, so remember the 2 purposes of pleadings. What happened? What do you want? So the what happened are the facts. And those go in those numbered paragraphs. This is where you're saying to the judge, here's an outline of what we believe happened. So number 1, she says she's a citizen of Multnomah County. Number 2, Coastal Insurance Company is incorporated in the laws of Georgia. It has its usual place of business in Savannah, Georgia. Number 3, On or about July 5th, 2012, plaintiff Smiles, defendant Coastal Insurance, and Anthony Caruso entered into a contract which is attached as Exhibit A. Contract was signed by all parties or their agents in Multnomah County, Oregon. All right? I'm going to stop right there. Paragraph 1, 2, 3. Who cares? Why is that relevant? Who cares where she lives? Who cares where they're incorporated?
Establishing jurisdiction.
Jurisdiction, exactly. So one of the things that you're required to do is make sure you put enough information in the complaint so a judge can read this and say, okay, there's jurisdiction here. Is there jurisdiction, by the way? What court was this filed in? Multnomah County Circuit Court for the state of Oregon. How does the Multnomah County Court get jurisdiction? There's a couple different ways. What's the connection? What's the connection with her? She lives there. There's another connection. What is it? Signed the contract there, right? What's the connection with Georgia Insurance Company? They're doing business in Multnomah County, and they signed the contract there, right? So there's two. All right. So that's why that's important. Jurisdiction. All right. Number 4. Contract obligates Coastal to pay Smiles the sum of $2 million if Anthony Caruso should die accidentally. Number 5. On or about September 20th, Anthony Caruso accidentally drowned and died while swimming. 6. Coastal has refused to pay any amount under the contract, any sum. And then finally, number 7. Coastal has knowingly, willingly, and unreasonably refused to honor its obligations. Okay? So 7 numbered paragraphs. This is the what happened part. Now we get down here to the wherefore. This is what you want. We call this the prayer. This is what you're asking for. Wherefore, plaintiff Smiles demands judgment against Coastal for all money due under the contract. How much is that? $2 million. Semicolon. What you can read is and demands triple damages for Coastal's knowing, willing, and unreasonable refusal to honor their obligations. So how much is that? Triple. $6 million, right? And all costs and attorney fees with interest. So how much? Total. $8 million, right? $2 million on the contract, $6 million for triple damages for bad faith, plus attorney fees, costs, and interest. So $8 million plus. Now, what's going on? The purpose of pleadings. What happened? What do you want? The idea of this is to give the judge an outline of what the case is about. Is it every little detail? No. But it's enough information that a judge can read it and say, okay, I know what this case is about, more or less, in an outline type format. Right? Who files the complaint? Which side? Plaintiff. Make sure you know that. I will test you. That's a test question. Which side files the complaint? Plaintiff. Or defense answer. I'll get to that in a minute. All right. So first thing I'm going to do, sorry, back to page 27, I think it is, yes. So step 1, I'm going to file a complaint. Now, step number 2, I then have to serve the defendant, in this case the insurance company, with a summons and a copy of the complaint in order to notify the defendant that they've been sued. I have to give them notice of the lawsuit. So let me show you a summons real quick. Page 34. All right, this is a summons. So basically a summons is kind of like an invitation to a party, sort of. And it's one that you better show up for. You better RSVP, respondez-vous s'il vous plaît, right? Because otherwise you're going to have a problem. That is, you're going to be in default. Default. So, let's look at a summons. This is an actual summons from 2001. Wow, gotta update my material here. So take a look at this right here. This would be served by a sheriff's deputy or a process server on the defendant, right? So they knock on the door in the middle of the night. Here you go, you've been served. You're hereby required to appear and defend the complaint filed against you in the above entitled matter within 30 days of date of service of this summons upon you. And in case of your failure to do so for want thereof, plaintiff will apply to the court for the relief demanded in the complaint. So you've got 30 days to respond or you will lose by default. Just like in sports, if you don't show up for the game, you forfeit, you lose by default, right? Same thing in court. If you don't show up, you lose by default. So if they don't respond in 30 days, I'm going to file for a default, and how much will I get? $8 million plus attorney fees, costs, and interest. It's a nice day. So I'll probably take a third of that as a commission. Be a good day, right? So what do they got to do? They got to appear. In this case, where the other side will win automatically. I apologize for the bad time. The real world, it's about this big. To appear, you must file with the court a legal paper called that says motion or answer. Motion or answer. 30 days, motion or answer. Back to page 27. So here we go. Number 4. Next step. I serve the defendant. Now their lawyer is going to file a motion or an answer. Oh, I forgot to say. The handwriting on the summons, the reason I put that on there, if you're ever served with a summons, the first thing I want you to do is get out a blue pen, not black. I like blue because I know it's original. Nowadays with digital imaging, I can't tell if black ink is original or not. Blue I can. So blue ink, I want you to write down the date and the time that you were served with that summons. Don't freak out, write it down, and then sign it or initial it. And the reason why is that's when the clock starts running, 30 days from that day. The first question I'm going to ask you if you show up in my law office with the summons, when were you served? Oh, I don't know, a couple months ago, I think it was like Thanksgiving or something. It's all crinkled up. I'm not taking that case. I'm not going to take it if it was the week before, because I'm not going to have time to respond in time, right? So that's the first thing I'm going to ask you, because we've got 30 days from that date. Now, you may have already lost, right? So that's why I put that on there. Okay, back to this. Summons and complaint. So next, the attorney for the defendant is going to either file a motion to dismiss or an answer. So let's talk about that. Not and, or. So first, we're going to look at a motion to dismiss. Now, a motion is when you're asking a judge to do something procedurally. So in this case, I'm going to ask a judge to dismiss the lawsuit right away at the beginning. Now, that's usually going to be for one of two reasons. There are more than that, but the two major ones, two common. First of all, if it's the wrong court. So, a motion to dismiss for lack of jurisdiction. It's the wrong court. So what's the judge going to do? The judge is going to look at the complaint, read through it, and try to figure out, is it the correct court? And if it's not, the judge will dismiss the case. That's one reason. The other reason is if the case is too old. It's called a statute of limitations. Was it filed in time? Now in Oregon, for a breach of contract, it's 6 years. 6-year statute of limitations. For an automobile accident, 2 years. Much less. So our case is 6-year statute of limitations. All right. Go look at the complaint and tell me, was it filed in time? And I will tell you right now, we don't know exactly. The can you kind of guess if it was filed within 6 years? In other words, would there be grounds for a motion to dismiss? When did they sign the contract? July 5th, 2012. All right, so is it 6 years from that date? No. But that's, going to give us a ballpark. When did Anthony die? September 20th, 2012. So is it 6 years from there? Is that gone? 2018? We beyond 6 years? Yeah, we are, aren't we? But that's actually not when it begins to run. It begins to run when they denied the claim. We don't know when that was, but we think it was a couple months after he died from the fact pattern. So it's possible that they didn't file this lawsuit in time, which means that we could file a motion to dismiss because it wasn't filed within 6 years, right? Just to give you an example, okay? In the real world, most of the time, you don't file a motion to dismiss because it's either within the statute or it's the correct court. And this is the correct court. All right. Excuse me. So, in that case, assuming there's no motion to dismiss, then the defendant, their lawyer, will file an answer to the complaint. And you'll see over here, C-A-D, the first three letters. Major steps I want you to know. Complaint, answer, okay? Complaint, then answer. So let's look at an answer. Answer is the second type of pleading. It's filed by the defendant, by their lawyer. The purpose of the answer is to respond to the complaint, to tell the judge what your answer is to the complaint. Here's my answer to what they're saying about me, basically. So look at page 36. Again, this is highly abbreviated, but you get the point. So here we are on pleading paper again. Now it's the answer instead of the complaint. So you see here, Coastal Insurance Company answers the complaint as follows. And then it's real short and sweet. Admit, 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 deny, admit, deny. Right? So what are they doing? If you look at the complaint, you got to read them together. Admit paragraph 1, admit paragraph 2, admit 3, admit 4, deny 5, admit 6, deny 7. Right? So what's going on there? They're narrowing down what's in dispute. That way a judge can say, okay, this whole lawsuit then is going to come down to 2 paragraphs. Which 2? 5 and 7.
What did it go down to 6 also?
They admitted 6. So they admitted they didn't pay any money. But they denied 5 and 7. So they're saying, I would, if they're a lawyer, I probably wouldn't have admitted that. But even though it's true. So 5 is the big one. What's the one word in number 5? That's the most important word of this whole lawsuit. Accidentally. This whole lawsuit's going to come down to that one word right there. So that's what all the evidence in the lawsuit you're going to focus on. Was it intentional death or was it accidental death? And that's what all the evidence, you're going to focus on all of it. Right? And then you're going to focus on, did they refuse in bad faith? And that basically means they knew there was evidence, they didn't have the evidence to the contrary to prove it was intentional. So what just happened? I just want to show you guys something kind of interesting. So let's say I'm a judge now, and I get this case as part of my caseload. This is an $8 million lawsuit. Literally, I can read both these documents in about 1 minute. And in 1 minute, I have a pretty good idea of what an $8 million lawsuit's all about. Literally that quickly. That's kind of the idea of pleadings. Now, every little detail, no. But enough for me to understand more or less what's going on. That's the basic idea. Okay, so let's go back to the pleadings page on 29. And then we'll get through this and then we'll be done for tonight. So, pleadings. So we have answer to the defendant's complaint. So that's one type of pleading. Now sometimes you have a situation where the plaintiff did something wrong as well. Remember, the plaintiff is the one who filed the lawsuit and did something wrong against the defendant. And so the defendant wants to claim back against them as part of the lawsuit. So let me just kind of give you a goofy example. Let's say that you ran me over with your car when I was in the crosswalk and you broke my leg. You're at fault, you should have stopped, I'm a pedestrian. So I go to the hospital, they fix my leg, I get out of the hospital, I'm on crutches with a cast, I come over to your house, I ring the doorbell, you open the door, and I punch you in the face. Battery, right? So I sue you for breaking my leg. You file an answer, and in the answer you say, counterclaim number 1. So this is a lawsuit back against me for punching you in the face, right? So I sue you, you basically sue me back. It's the American way, right? It's just trade lawsuits. So that's called a counterclaim. Or it could be, I want you to pay my attorney fees. If I win, I'm the defendant, you sue me and I'm saying that I have a better case. So I have to counterclaim against you for my attorney fees. You get the idea. So if you do that, then I have to file what's called a reply to your counterclaim. And I have to admit or deny what you're saying I did wrong. So that's what's called a reply. The plaintiff files in response to the counterclaim. Does that make sense? All right, number 4. This is kind of a cool one. Sometimes you have a situation where we want to have more people come to our party. Just the 2 of us is boring, so we're going to bring somebody else, a third party to the party. It's called a cross-claim. Now, real world, no more tongue-in-cheek. This is when somebody else is at fault for what happened, and they need to be brought into the lawsuit. So let me give you an example. My dumb little drawing down here. Okay? So this is a stoplight. Here I am in my car, waiting for the light to turn green so I can go. Minding my own business. Perfectly legal, just sitting there. You drive up behind me and you stop, waiting for the light to turn green. You're minding your own business. You're like 3 feet back. You're all good. Along comes dump truck driver, going 50 miles an hour. Doesn't notice it's a red light. Runs into you. You then run into me, right? I get hurt. So I sue you for rear-ending me. Hey, you ran into me. But I don't sue dump truck guy. Maybe I don't even know about dump truck guy. I'm just like, hey, you just ran into me at a red light, whatever. So I sue you. So what are you going to do? Well, I file a complaint against you. In the answer, you say, it was not my fault. I was legally stopped behind when dump truck driver ran into me, and I then ran into you. So really, it's dump truck guy who's at fault. And then you're going to file a cross-claim against dump truck guy and bring dump truck guy into the lawsuit. Bring somebody else to the party, right? And then dump truck guy will be served with the complaint, the answer, the cross-claim, and then dump truck guy will have to file an answer to the counterclaim of the defense. It's kind of confusing.
Could you go directly towards the dump truck if you know he's what caused it?
If I knew about dump truck guy in real world, I'd sue both of them, because there might be partial fault, which we're going to talk about that. I don't know if we'll get to it next week or the week after. It's called comparative fault. So like the jury may say, okay, well, it's 90% dump truck, 10% you because you stopped too close, right? But long story short, yeah, if I knew about it, I'd sue both of them and let them figure it out. So that's a cross-claim. Now that's actually fairly common, not so much in automobiles, but also like in medical malpractice for surgery, where you may have more than one doctor that was doing the surgery or involved, or maybe more than one doctor that misdiagnosed a disease or something. So here's what I want you to know for the test. Number 1, on this page, list 4 types of pleadings, fill in the blank. List 4. Number 2, Which side in a lawsuit creates the pleading? Here's how you can remember. Complaint has a PL. Plaintiff has PL. PL. Plaintiff. Reply. PL. Plaintiff. PL. So the pleadings that have the PL are from the plaintiff. The rest of those don't have PL. Answer, counterclaim, cross-claim. That's how you can remember, okay? Again, the main two, the most important two, first two. And again, what are the purposes? What happened and what do you want? Okay, so next week, remind me where we're going to pick up is right here on this word remedy. And I want to talk to you about legal and money and non-money. So remind me. All right, have a good weekend. Well, not quite the weekend yet, but for me.